Federal Judge Paul Engelmayer couldn't conceal his amusement as former Florida Attorney General Pam Bondi approached the podium in his Manhattan courtroom. His dismissive chuckle, captured by courtroom cameras and quickly shared online, would soon become the most regrettable moment of his distinguished judicial career. What followed in the next 17 minutes left legal experts reeling and forever altered the course of one of the most high-profile constitutional cases of the decade. The instant Bondi opened her briefcase and produced a document the government never thought she'd find, Engelmayer's smirk evaporated. By the time she concluded her argument, the gallery was buzzing with gasps, and the judge who had laughed at her was left utterly speechless. If you've ever been underestimated by someone in power, you'll want to see how Pam Bondi delivered. The legal equivalent of a knockout punch to a federal judge who should have known better. Like and subscribe to see more stories of brilliant legal minds turning the tables on those who dismiss them too soon. The footage makes it plain. As Bondi rose from the defense table, Judge Engelmayer leaned toward his clerk with a faint but unmistakable smirk. "Let's see what approach she takes this time," he murmured, his voice just loud enough to be picked up by courtroom microphones. The seasoned legal reporters and attorneys in the gallery shifted uncomfortably at the judge's transparent condescension, but Bondi didn't flinch. She simply straightened her papers, adjusted her glasses, and approached the podium with the calm assurance of someone who knows something no one else in the room does. Within minutes, what had begun as a routine hearing in a seemingly predictable case was transformed into one of the most electrifying legal showdowns in recent judicial memory. Judge Paul Engelmayer was no stranger to complex litigation. Appointed to the Southern District of New York after a stellar career as a prosecutor and private attorney, he had built a reputation as one of the sharpest legal minds on the federal bench. At 63, he had presided over thousands of cases and was known for his incisive questions and meticulously crafted opinions. His courtroom was his domain, and he exuded unwavering confidence in his own intellect. The case before him involved a constitutional challenge to a newly enacted federal regulatory framework governing interstate medical data transfers. The government insisted these rules were crucial to national healthcare security, while the plaintiffs argued they violated Fourth Amendment protections and overstepped congressional authority. As lead attorney for the challengers, Bondi was fighting an uphill battle against both established legal precedent and a judge who had signaled from the start that he was skeptical of her arguments. Pam Bondi brought her own formidable pedigree to the courtroom. As Florida's first female attorney general, she had overseen thousands of cases and argued before the Supreme Court multiple times. After leaving office, she became known as a tenacious constitutional lawyer with a keen eye for federal overreach. At 56, she combined decades of courtroom experience with the instincts of a seasoned prosecutor, always searching for the overlooked detail that could change everything. The stakes extended far beyond this courtroom. The regulations under challenge affected how medical information could be shared across state lines, potentially impacting everything from rural telehealth services to emergency care for out-of-state travelers. Major healthcare systems had invested millions in compliance measures, while privacy advocates warned of a dangerous expansion of government access to sensitive personal data. For Judge Engelmayer, this case offered a chance to shape the emerging legal landscape at the intersection of technology, privacy, and federal power, a ruling that would likely be cited for decades. For Bondi, it was both a professional and personal crusade. Beyond defending her clients, she viewed the regulations as a dangerous federal encroachment that could set a troubling precedent. And she knew that Judge Engelmayer had grown increasingly dismissive of her arguments in earlier hearings. In a preliminary ruling he'd written, "Miss Bondi continues to raise interesting theoretical concerns, but theory must eventually confront legal reality." That condescension had reached its peak in today's hearing, where he was expected to issue a ruling that would effectively hand victory to the government. Meanwhile, the Justice Department attorneys sat at their table, confident that victory was inevitable. Unaware that Bondi was about to reveal the one detail they never saw coming, they exchanged knowing glances as Bondi rose to deliver her final argument. What no one knew, not the government attorneys, not the assembled press, and certainly not Judge Engelmayer, was that Bondi had spent the last 72 hours following a paper trail that would flip the entire case upside down. As she stepped up to the podium, facing the still smirking judge, Bondi knew the next 15 minutes would either vindicate months of painstaking work or confirm Engelmayer's dismissive view of her arguments. Either way, she had no intention of leaving the courtroom without forcing him to take her seriously. "Your Honor, before you issue your ruling, I would like to address 3 critical points that have emerged since our last hearing." Bondi began, her voice steady and resolute. Judge Engelmayer leaned back slightly, his smirk widening. "Miss Bondi, I've reviewed your supplemental brief thoroughly. I'm not sure what you believe has emerged that wasn't already covered in your previous arguments, but please proceed." The subtle emphasis he placed on emerged drew a few chuckles from the government's table, which he made no effort to discourage. "Thank you, Your Honor," Bondi replied evenly. Undeterred, "My first point concerns the department's repeated assertion that these regulations were developed after extensive consultation with healthcare privacy experts and affected stakeholders." She removed a document from her folder and handed it to the clerk. "This is a complete record of the official stakeholder meetings conducted during the regulatory review period. It was obtained yesterday through a Freedom of Information Act request." Judge Engelmayer accepted the document with a flicker of impatience. "Miss Bondi, the administrative record has been closed for months. The time for submitting procedural objections has long passed. I understand, Your Honor, but this document wasn't available during the administrative record compilation, despite our repeated requests. I believe when you review it, you'll understand why." The judge flipped through the document, his expression unchanged. "I see a list of meetings with various healthcare associations and privacy groups. This seems to support the government's position, not contradict it." Bondi leaned in slightly. "If you look at page 3, Your Honor, you'll notice that all of these consultations occurred after the regulatory framework was finalized. These weren't input sessions, they were implementation briefings. The government has misrepresented them as collaborative development meetings in their filings. This document proves that no stakeholder input was actually incorporated before the regulations were finalized." A subtle shift rippled through the courtroom. Attorneys on both sides began flipping through their own notes, tension rising. Judge Engelmayer's clerk whispered something in his ear, causing the judge to focus more intently on the page Bondi had referenced. "Even if that's the case, Miss Bondi," the judge said after a moment, "procedural irregularities of this sort would typically result in a remand to the agency for proper process, not the kind of substantive invalidation you're seeking." "That would be correct under normal circumstances, Your Honor," Bondi replied calmly. "However, my second point addresses why these are not normal circumstances." She produced another document. "This is an internal department memorandum discussing the constitutional concerns raised during the drafting process. It explicitly acknowledges that the proposed regulations likely exceed the authority granted by Congress under the enabling statute." As the document was passed to the judge, the government's lead attorney, Thomas Reed, rose abruptly. "Your Honor, the government has no knowledge of this document. We object to its introduction until we can verify its authenticity." Judge Engelmayer's expression had shifted. The smirk was gone, replaced by professional concern. "Where did you obtain this document, Miss Bondi?" "It was provided by a whistleblower within the department, Your Honor," Bondi replied. "I can submit an affidavit regarding chain of custody. The document's metadata and signature blocks can also verify its authenticity, but the most compelling verification is in my third exhibit." With deliberate precision, she presented her final document, a set of email exchanges between senior department officials. These communications show that the department was fully aware the regulations exceeded statutory authority, but proceeded anyway because they believed. She paused, her eyes meeting the judges, and I quote directly from the department's chief counsel. "Courts will likely defer to agency expertise even where the statutory authorization is ambiguous." The courtroom fell utterly silent. The courtroom fell completely silent as Judge Engelmayer reviewed the emails, his expression growing increasingly troubled. At the government's table, the attorneys huddled, papers shuffling in an urgent scramble for a response. "Your Honor," Reed finally said, standing again with a measured tone, "without conceding the authenticity of these documents, I must note that internal deliberative discussions often consider a wide range of perspectives, including potential challenges. That doesn't invalidate the final regulatory determination." Judge Engelmayer nodded slowly. "A fair point, Mr. Reed." He turned back to Bondi. "Ms. Bondi, even accepting these documents at face value for this hearing, they suggest procedural irregularities and internal debates. But the legal standard for overturning agency regulations is extraordinarily high. Agency actions are entitled to substantial deference under Chevron and its progeny." This was the moment Bondi had prepared for, the point where her preparation would meet opportunity. "That's precisely the issue, Your Honor," she said calmly. "The government's entire defense rests on Chevron deference, but these documents demonstrate something far more serious than mere procedural irregularities." She paused deliberately, ensuring she had the judge's full attention. "They reveal that the department deliberately expanded the scope of the regulations beyond what they believed Congress had authorized, counting on judicial deference to shield that overreach from meaningful review. This isn't a case of an agency interpreting an ambiguous statute. It's a strategic exploitation of judicial deference to circumvent constitutional limits on administrative power." The judge's demeanor transformed completely. His earlier dismissiveness vanished, replaced by focused intensity. He turned back to the government's table. "Mr. Reed, how does the government respond to this characterization?" Reed stood, visibly uncomfortable. "Your Honor, we would need time to review these purported documents before offering a substantive response. However, I would emphasize that internal discussions exploring the legal boundaries of potential regulations are a normal part of the agency process." Bondi cut in smoothly. "Normal process includes considering whether regulations might be challenged. But these documents show something different, a deliberate strategy to exceed known statutory limits while using judicial deference as a shield. The Supreme Court has never extended Chevron to protect this kind of conscious overreach." A hush fell over the courtroom. The tension was palpable as Judge Engelmayer weighed both arguments. What had begun as a routine application of administrative law now hovered on the edge of a potential landmark ruling. The judge, who had laughed at Pam Bondi not 15 minutes earlier, was now leaning forward, brow furrowed in concentration, his amusement entirely gone. Everyone in the courtroom sensed it. The ground had shifted beneath their feet. "The court will take a 30-minute recess," Judge Engelmayer announced abruptly. "Miss Bondi, Mr. Reed, I want both of you in my chambers immediately." As he exited the bench, the courtroom erupted in hushed conversation. Legal reporters rushed out to phone their editors. Law clerks clustered in corners, debating the implications of what they'd just witnessed. Inside the judge's chambers, the confrontation continued away from public view. Though no transcript exists of that private discussion, 3 individuals who were present later described what transpired. Judge Engelmayer spoke first, addressing the elephant in the room. "Miss Bondi, I owe you an apology. My reaction at the beginning of your argument was inappropriate and unprofessional. However, I'm also deeply concerned about how these documents came into your possession." "I understand your concern, Your Honor," Bondi replied. "But the whistleblower followed all proper federal procedures before providing these materials. The documents were first submitted through internal channels, then to the relevant Inspector General, and only reached my client when those avenues proved unresponsive," Reed interjected forcefully. "Judge, regardless of how she obtained them, these documents represent internal deliberative processes that are protected from disclosure. We move that they be excluded and that counsel be sanctioned for introducing them." Judge Engelmayer considered this for a moment. "The deliberative process privilege isn't absolute, Mr. Reed, particularly where there's a colorable claim of impropriety. What concerns me more immediately is whether these documents are authentic. Miss Bondi, can you establish their provenance without compromising your whistleblower?" "Yes, Your Honor," Bondi replied steadily. "The metadata in the electronic versions confirms their origin within the department systems and identifies the authors. I can also provide sworn declarations from 2 former department officials who can authenticate the documents based on format, content, and signature blocks without revealing the whistleblower's identity." The judge nodded slowly. "Very well. Mr. Reed, the government will have 48 hours to verify or challenge the authenticity of these documents. If they are authentic, I expect a substantive response to their content, not merely procedural objections to their introduction." Reed's expression tightened. "Your Honor, with respect, these deliberations are precisely the kind of internal agency discussions courts have long recognized need protection to ensure candid and thorough consideration of regulatory options." "I'm familiar with the deliberative process privilege, Mr. Reed," Judge Engelmayer replied dryly. "What Miss Bondi has alleged goes well beyond protected deliberation. If these documents are authentic, they suggest a deliberate strategy to exceed statutory authority while using judicial deference doctrines as a shield against review. That raises fundamental questions about the separation of powers and the proper role of courts in reviewing agency actions." When they returned to the courtroom, Judge Engelmayer addressed the packed gallery. "In light of the material submitted today, I am postponing my ruling on the government's motion to dismiss. The court will issue an order this afternoon, establishing a schedule for additional briefing on the issues raised by these new documents. In the interim, the temporary stay of the regulations will remain in effect." The judge's measured tone belied the seismic shift that had just occurred. A case that had been on the brink of dismissal was now headed for full consideration on the merits, with the government on the defensive. As the courtroom cleared, legal observers immediately recognized the significance of what they'd witnessed. Joyce Vance, former U.S. attorney and legal commentator, captured the moment in a viral tweet. "Just watch Pam Bondi pull off the legal equivalent of a mic drop in SDNY. Judge's eye roll turned to jaw drop in 15 minutes flat." For her part, Bondi maintained her characteristic composure as she exited the courthouse into a sea of reporters. Asked about the judge's initial dismissive reaction, she offered a measured response that would soon be widely quoted in legal circles. "Every lawyer has experienced being underestimated at some point in their career. The only appropriate response is meticulous preparation and unwavering focus on the merits. Judge Engelmayer is a brilliant jurist who ultimately engaged seriously with the constitutional issues we raised. That's all any advocate can ask for." Behind Her diplomatic answer was the reality everyone had just witnessed. A federal judge who had openly mocked her had been forced to completely reverse course when confronted with her devastating legal evidence and argument. The laughter had stopped, replaced by the serious judicial consideration her case had deserved from the start. The consequences of that dramatic hearing rippled outward in the days and weeks that followed. 48 hours later, the government filed a terse notice confirming the authenticity of Bondi's documents, though maintaining that they had been taken out of context and did not reflect the department's comprehensive legal analysis. This reluctant authentication only amplified the impact of Bondi's revelations. A week after the hearing, the Washington Post published a detailed investigation into the regulatory process, revealing that senior officials had explicitly instructed staff to draft broadly and let the courts sort it out. Internal emails quoted an unnamed official stating, "Savan gives us room to run. We should use it." The fallout extended beyond this single case. Law schools began incorporating the hearing transcript into administrative law courses as a case study in the limits of agency deference. Legal blogs and major newspapers published analyses with headlines like "The Bondi Bombshell, Rethinking Chevron Deference," and "When Agencies Count on Courts Not to Look Too Closely." 2 months after the hearing, Judge Engelmayer issued a comprehensive 87-page opinion that sent shockwaves through administrative law circles, while carefully avoiding sweeping pronouncements about Chevron deference more generally. The court ruled that when agencies knowingly exceed their statutory authority and then rely on judicial deference to shield themselves from review, judges must scrutinize those regulations more closely. The foundation of judicial deference under Chevron and its progeny assumes that agencies are honestly interpreting ambiguous statutes. But Judge Engelmayer wrote that when there's evidence an agency has intentionally gone beyond what it believes Congress authorized, counting on deference to protect it, the very premise of that deference collapses. His ruling struck down major parts of the regulations and sent others back for reconsideration within proper statutory limits. Legal experts immediately saw it as a landmark decision that could reshape how courts and agencies interact. For Judge Engelmayer, it was a personal reckoning. Known for his intellectual self-assurance, he realized that same confidence had caused him to dismiss valid arguments because of biases about the attorney presenting them. In a speech to Yale Law School, 3 months later, he admitted, "The most dangerous moment for any judge is when we think we already know the answer before hearing the argument." Without naming Pam Bondi directly, he said, "I was recently reminded of this in a case where an advocate I underestimated changed my entire understanding of the legal issues. It was humbling, but it made me a better judge." For Bondi, it was a career-defining victory. She received the American Bar Association's Distinguished Advocacy Award and was featured in top legal publications. Applications to her firm surged, especially from young women inspired by her tenacity. Yet in an interview with the Florida Bar Journal, Bondi downplayed personal vindication. This case was never about confronting a judge or embarrassing the government, she said. It was about upholding the constitutional principle that agencies cannot exceed what Congress authorizes, and that courts must enforce those limits. The government initially filed a notice of appeal, but after a new administration came in, it quietly withdrew the challenge. The new leadership began drafting revised regulations that better respected statutory boundaries, while still addressing the legitimate healthcare data security concerns that had motivated the original rules. The case's deeper impact was felt 6 months later, when the Supreme Court agreed to hear a similar case challenging Chevron's limits. Legal briefs from both sides cited Judge Engelmayer's opinion and the now famous hearing where Bondi transformed what had started as a routine regulatory dispute into a turning point for constitutional law. Judge's dismissive chuckle had sparked a serious re-examination of one of administrative law's core doctrines, all because one advocate refused to be underestimated and prepared meticulously to seize her moment. For anyone watching the case unfold, the lesson was clear. Legal brilliance isn't just knowing the law. It's having the determination and courage to stand your ground, even when those in power doubt you. Sometimes the most powerful arguments come from the advocate no one saw coming. If you enjoyed this story of an underdog lawyer outsmarting those who dismissed her, like and subscribe for more courtroom drama and tales of legal brilliance. Share in the comments about times in your own work when preparation met opportunity and changed everything.